Thank you so much for coming to our Reasonable Accommodation Roundtable. I'm Elizabeth Gordon. I'm from the Governor's Committee on Disability Issues and Employment. And we plan to have these periodically and have them available both online and then have the materials available online after this. And so we're very excited that you're joining us. I'm really happy today because we have Laura Wolf from the Attorney General's Office and Connie Minton from DSHS to talk to us about Reasonable Accommodations 101. We did a survey and asked people what they would like to hear, and one of the things that came out was that people would like that baseline information because people are entering all the time and it's always good to have that updated information. So before we get started with our presentation, I'd like to go briefly around the room and just hear who's in the room. For those of you who are listening on the phone, I am monitoring your chat. You won't be able to interact with us via audio, but if you put your questions into chat, I'll make sure that those get given to our speakers. And let's start over here with Ayana. Please introduce yourself and where you work.
Okay. Okay. So I am Laura Wolf, and I'm with the Labor and Personnel Division here at the AG's office. I've been doing reasonable accommodation cases for about 20 years now, I guess. I don't know. I was just telling someone that when we first started this group, it was Eleanor Limas, who was an AGO employee, and Sandy Davis, who worked at DOR. And we saw the need for there to be a group of people that do RA in their agencies to have the opportunity to get together and talk about, you know, what the law is, what specific cases look like, to get help in sort of a peer-oriented way sometimes. So now this group resides over at OFM. They staff it at State HR, so we appreciate the fact that they do that. And I just want to call out before I forget Eric Carlson, who's running the Zoom today and has been very helpful from the AG's office. And I really appreciate his help with staffing this afternoon. So with that said, we have a PowerPoint, which is up on the screen. As I understand it, Tammy Petrie is going to make sure that this gets sent out to folks after the presentation today. And I'm not sure if people on Zoom already got that. They may have, I'm not sure. But we'll send it out to the list of participants so you can have it later for your education later and for, you know, to remember what happened today. So what are our objectives today? One of the things is we're going to talk a little bit about the CBA and how it affects reasonable accommodation cases. And primarily we talk about the WFC contract, but there are articles in each of the different contracts you might work with that deal with reasonable accommodation. If you have specific questions about any of those, please feel free to go ahead and tell us. I think Connie and I both did agree too that if you have questions during the presentation, that you should go ahead and ask them at the time that you have the questions, either those of you here in person or folks on Zoom, and we will do our best to answer those questions if we're able to. The only caveat that Connie and I always give is make sure that you're asking hypothetical questions, because obviously we don't want anyone to be talking about real, true cases, or in particular, anyone's medical information in a public setting like this. So that's the one caveat. But hypothetical questions are always welcome, as are any other kinds of specific questions. Let's see, I'm going to talk a little bit first about the differences between the ADA and Washington law against discrimination, because we do have both a state law in Washington that's usually been considered to be more liberal, and also a federal statute, which most of you are familiar, at least with hearing, I think, about the ADA, the Americans with Disabilities Act, which was passed in 1990. Our state law was actually passed, I think, in 1973. So actually in Washington, we've had protection against discrimination for folks with disabilities for even longer than at the federal level. Let's see, as a supervisor, these are the kinds of things you want to be able to do as a reasonable accommodation specialist, to talk to your supervisors about what triggers my obligation to address a reasonable accommodation. And that's really key, because I think both Connie and I can both talk about bad fact scenarios where a supervisor has missed that opportunity to understand what an employee was trying to convey to them. And that can really result in a problem down the road if we're not following the interactive process. So we'll talk more about that. What do I need to know to complete the essential functions portion of the PDF? That's really important, because obviously when no one's in the position and you're writing the PDF, that's the best time to have the essential functions put in. The very worst time, of course, is when someone's in reasonable accommodation and all of a sudden the manager says to you, well, this isn't really what I want this job to perform. I want it to do all these things, which, by the way, this person probably can't do. So that's not a good scenario either. So we can talk more about essential functions. If it leaves a reasonable accommodation, how is it managed? Really important. And now actually Connie's not only the reasonable accommodation manager, but she's the leave manager at DSHS. So I'm sure you have lots of thoughts about managing leave, right? As we all do. And then finally, when does the department initiate a disability separation? I should say about this that we're using Connie's PowerPoint, and as you noticed in the beginning, it talked about it being a DSHS PowerPoint. It's similar to the ones that I've used before in the AG's office. It covers a lot of the same materials, and it was just kind of her to let us use it today because it made it easier for me, for sure. So let's talk about the Americans with Disabilities Act. George Bush actually is the one who signed this into law, as I said, in 1990. And it was intended to be, and I believe that it is, a strong idea about how folks with disabilities should be able to be in the workforce. And that's something certainly that our Governor Jay Inslee is really promoting. And we're trying to figure out ways that we can be inclusive of everybody and have folks have an opportunity to have gainful employment. Because I'm sure as much as sometimes, you know, on Monday morning you might not want to come to work, the idea of not being able to come to work is probably more upsetting, because not only does it obviously fulfill your financial need, but it also gives people a sense of belonging and of accomplishment to be able to come to work every day and do a job. So everybody should have that opportunity, and that's the idea behind the Americans with Disabilities Act, is to give everybody an equal opportunity to have that opportunity to work. So that was kind of the idea behind it. It prohibits covered employees, which are folks with 15 or more employees, which is essentially every state agency. And it covers recruitment, hiring, firing, job assignments, job training, promotions, compensation, and other kind of privileges of employment. Sometimes you don't think about these things, but like, what's the experience like for your employees? So what opportunities might somebody miss if people are not thinking about this? I remember once I was I advised a Department of Health commission, and we all were going out to lunch. And one of the commissioners was coming to lunch with us, and somebody had made a reservation at this restaurant where you had to go up steps. And this particular commissioner used a wheelchair. And so that was not that was not good because that did not allow that person to enjoy the same privilege and opportunity as everyone else. So obviously we made a change about what we were doing there. The Washington law against discrimination. So we call this WLAD. Sometimes it kind of comes out WLAD. But this is it's a broader statute, and the focus of this really is to not discriminate against people because of particular characteristics or situations that or groups that they belong in, right? So it's a slightly different point of view, I guess, than the ADA, but we use it for the very same purpose in terms of providing reasonable accommodations to folks. The WLAD, or Washington Law Against Discrimination, does cover more than just not discriminating against folks who have a disability. It also includes things such as race and sexual orientation, military service, all those kinds of things. It calls out actually using a trained guide dog or service animal. We'll talk a little bit more about that a little bit later. But so it really is a broad coverage, and the point of it is that employers are not allowed to discriminate against people because you're in any one of those classes, including someone who may have a disability. If you're making a distinction about this particular employee because of being in that group, that's what's prohibited. So some of the similarities between the ADA and the WLAD, or whatever we call it, prohibit discrimination against disabled persons, persons having a history of being disabled, and persons perceived as being disabled. So you kind of see three notions there in that. We're going to talk a little bit about each of them, but really we're mostly focusing on the first one, current employees and trying to accommodate them. And by accommodating them, then we haven't failed to accommodate them, and then we're not open to some lawsuit that alleges that, right? It requires employers to reasonably accommodate the known limitations of a qualified individual with a disability. We're going to talk a little bit more about notice and knowledge. And it restricts disability-related inquiries and medical examinations in the pre-offer, post-offer, and employment stages. There's a slightly different things you can and cannot ask about someone's medical background or their medical information, depending on what stage of the employment process you're in. And again, we're primarily here in this training today going to be focusing on the phase where you are an employee and you have, you are working for an agency, and that's kind of where we're going to mostly focus today. But if you have questions about like in interviews or the conditional offer, we can talk about those too. In 2009, the ADA was amended. Whoops, sorry, definition of disability. So actually in both of these slides, I mean, what the bigger societal kind of conversation I think that was going on here was people were either, in Washington, there was a case that said, you know what, the Human Rights Commission has never adopted a definition of disability. That makes it really hard to apply in these court cases that we have. And, their definition pretty much says if you have a disability, then you can't discriminate against someone for having a disability. And they said, it makes us dizzy, it's circular, it makes no sense. So at one point, about 10 or 15 years ago, there was a case in which the Washington State Supreme Court said, you know what, we're tired of this. And we're just going to adopt the ADA definition of disability, which for people in Washington, particularly the disability rights community in Washington, that was not good news because it had been, at least the ADA, a much harder definition to apply, and not as many people were encompassed, right, in the group that could qualify for coverage. And so they went about, there's different branches of government, right? There's the judiciary, where the court decisions come from. There's the legislature, where laws are passed. And of course, there's also the executive, which we all work for, the governor. Well, I guess actually I don't work for the governor anymore. I used to work at DSHS and used to work for the governor. Now I work for the separately elected attorney general. In any event, let's see. So under WLAD, the definition of disability, then the legislature stepped in because the disability rights community said the Supreme Court screwed up here. We don't like this. And they passed a statute. They added it to 4960-040, which is...
We're on the ADA first.
We're on the ADA. I thought you said I was in the WLAD first.
Nope, ADA.
I was here, and then you said there. Okay, let's go back to the ADA. Well, no, you said definition of that's what's up there.
Well, you're on WLAD.
So where am I?
We're doing the ADA.
Oh, sorry. Okay, sorry. Thank you.
On her accommodations. So
Yeah, actually, I can't see very well today because my eyes are all dry. Sorry. Okay, so the definition of disability under the ADA: a physical or mental impairment that substantially limits one or more of the major life activities of an injured individual: walking, seeing, hearing, breathing, learning, caring for oneself, performing manual tasks. All these things could be major life activities, right? Or, again, this is the three things, right? You either currently have a disability, or secondly, you have a record of a disability or an impairment, or you're being regarded as having an impairment, even if you maybe don't have a disability at all, right? That's all ways to violate the ADA under this definition. And interestingly, under the ADA, also persons who associate with disabled individuals, like perhaps maybe your children or a spouse, if you're being discriminated at work because of that, that could be covered under the ADA. Interestingly, under the Washington law, that is not covered, your association with a person who's disabled. There's actually, again, a state Supreme Court case that says that doesn't get you coverage under WLAD. So that's a difference. There are a few differences between the two statutes and how we apply them. So applying this major life activity definition got really very confusing for people. And this is part of why when we talk about the amendments to the ADA, I think why they kind of came around, because there were these court cases that said, okay, look, if you stand at a Toyota manufacturing plant and you do this all day because you're polishing up the cars that come along the belt, and it turns out that it creates a problem for you in your shoulder, and it's a medical condition that really hinders you in your daily life. The U.S. Supreme Court actually said, well, but that's not a major life activity, going like that all day. So you can imagine how people reacted to that decision, right? Because clearly the job is, the thing that you're doing, whether we call it a major life activity or not, it's creating a medical condition that's impairing your ability to do the job that you were hired for. And it didn't make too much sense. So people, because of cases like that, there were changes that were made. Also, originally under the ADA, mitigating measures like eyeglasses or contact lenses were not, that wasn't a disability just because you couldn't see. So now, they still deal with those kinds of issues under the ADA, and they're not considered when assessing a disability. So if you can see because you're, fixed with glasses or contacts, then it doesn't count. So let's see. Let's now move on to the ADA and the amendments. Okay, so so the amendments, because of that background of these court cases that had sort of been limiting the scope on the national level of the ADA, the Congress came in and passed some amendments that are the ADAAA. And they expanded the definition of major life activities. They kind of fixed who's regarded or who is regarded as having a disability. And then the other thing that they did was, I think it was here that they said, if you don't have a disability, you don't have to be reasonably accommodated, which sort of made sense in a way, that you couldn't sue someone, right? Because as lawyers, we're always thinking about what's my cause of action? Why can I sue someone? And people actually did try to say, you failed to accommodate me, but I don't have a disability, right? And it was like, that doesn't make any sense. So they fixed that. Anyway, so those the changes that came into the ADA. I think those were important. But more importantly, I think actually for us was when the state legislature here in Washington took up this issue of the definition of disability in the state law. Because the Human Rights Commission hadn't been defining it in a way that they felt was, that the courts felt was helpful. So they adopted a little bit of what you might find in the ADA, some of similar language, but it's not exactly the same, and it's different in some kind of important ways. So here in Washington, we ask if you have a sensory, mental, or physical impairment, and whether or not that impairment is medically cognizable, or you can diagnose it, whether it exists as a record or history, or whether or not someone is perceived or whether the disability is perceived to exist, whether or not it exists in fact. So again, those three prongs, you kind of see those both in the ADA and the Washington Law Against Discrimination. But here in Washington, we said, look, a disability exists whether it's temporary or permanent, common or uncommon, mitigated or unmitigated, glasses or no glasses, whether or not it limits the ability to work generally or work at a particular job. So this was a little bit in response to a lot of the federal cases that had said, you know, if it's just a temporary disability, then it doesn't count. But in Washington law, the legislature made it very clear that we're more expansive, we cover more people, and we're going to cover those folks as well that have temporary disabilities. Okay. Where am I going next? Yeah? No. Is it your turn? I think this is your turn. Okay, now Connie's going to take over and talk
Does
a little
anybody
bit.
have any questions on anything that Laura's covered so far?
Go ahead. Do we need a microphone, Eric? Do we
But it's
need
for
for
the
this,
people
for the Zoom people? We can repeat the question, or we can get a mic. For right now, let's repeat the question. Go ahead and tell us your question. No. Pregnancy is not a temporary disability. However, and we're not going to cover that in this particular presentation today, but there is a new law here in the state of Washington that protects pregnant women or pregnant people in ways that hasn't previously been done. So there's like a few things that you can have as an accommodation, whether or not you even have any medical information or not, in terms of taking breaks and different things. And then there's some other accommodations you can get if you do have a doctor's note saying you need those accommodations while you're pregnant. So again, that's not something that we really cover here, but historically, no, pregnancy in and of itself is not a disability. It only could become a temporary disability if there was some other medical condition, like you needed to have bed rest or something for some medical condition, then it might be covered as a disability that would be temporary.
Yeah. So,
Uh-huh.
well, pregnancy-related medical conditions are considered a disability, and they do have protections under 4960, but they have so much more protections under the new pregnancy reasonable accommodation. So we defer to that law because it's much more expansive as far as what our obligations are under this law.
But if you have questions about that in particular, we can talk about that later, or you can talk to your AAG because we've done presentations on that as well at the PMM or other places.
Any other questions?
Any
online?
questions on Zoom?
I'm ready to use this microphone for someone.
Now you've got a microphone. What will you do with it?
All right. So again, if you have questions as we're covering the slides, please feel free to ask them, raise your hand, and we'll make sure your questions get answered. So as far as characteristics and physical traits, it may not be disability. Hair color, pink hair, blue hair, not a disability. You'd be surprised. Height, being too tall, being too short, not a disability. However, dwarfism is considered a disability, so we would consider accommodations for dwarfism. However, I don't know, I know DSHS, we get a lot of requests for accommodation for like motor pool cars because I'm too short or I'm too tall, the car doesn't fit me. They have no protections under this law.
Unless, of course, the driving around the car causes you to have a disability, in which case that's a whole nother ball of
Yeah,
wax.
that's different. But being tall, being short are not a disability. Weight, morbid obesity under the ADA, definitely a disability if it's caused by a medical condition. And just recently, earlier this year, you all probably found out that under Washington state law, it is considered a disability, and there are protections for individuals who are morbidly obese. Physical conditions. Again, we talked about pregnancy. Normal pregnancies are not considered a disability. However, if they do have a pregnancy-related medical condition that limits work in some way, they do have protections under 4960. But again, we don't, I know DSHS, we don't look at the protections under 4960 because the new pregnancy reasonable accommodation law is much more expansive and they have much more protections under that law. Personality traits, poor judgment, quick temper, irritability, not a disability. Laura had covered earlier on one of the slides that the employer is responsible for the known disabilities, where we have obligations for the known disabilities of our employees. I underline known only because the courts have been real consistent around the country and even in the Ninth Circuit. They are not going to hold the employer responsible for information that you did not have. So what I tell managers and supervisors when I go around the state and do training is that if you have someone with these traits and you're not aware of a disability, you meet with them privately, you call them into a private meeting room, and you cover that with them. Here's the issue, here's my expectation, how can I help you meet my expectation? You treat it as a performance issue. However, if the employee does disclose during that conversation that it is medically related, so maybe they have bipolar disorder and they disclose that their conduct issues are caused by that medical condition. Again, that now you are on notice. Now that triggers your obligation to begin addressing or at least offering reasonable accommodations at this point.
Do you cover, I'm not seeing notice in particular in here, but you just sort of covered it, but.
It is on here.
Is it? Okay.
On notice, yeah. There's a slide for that.
Because it's a little bit different between what the ADA will allow for and what the Washington law requires.
Correct. Okay. Yeah. So what we tell management is if you don't know, don't assume that it's related. You have a conversation with your employee. You present your expectations, and if the employee says it's medically related, offer reasonable accommodation and go down that process. Any questions? Okay. So reasonable accommodation is a legal term and it has a definition. Reasonable accommodations are an adjustment or changes to a job, work environment, policy, practice, or procedure that enables a qualified person with a disability an equal employment opportunity. Reasonable accommodations are to provide access to the recruitment and application process. So those who are applying and competing for positions, we have obligations to accommodate them, and also in the interview process. Allow employees to perform the essential functions of the job, and to ensure that employees have an equal opportunity to participate and benefit from the benefits and privileges of employment. So you guys are in training today. Do you see this as a benefit and privilege of employment? So would the employer have obligations to accommodate an employee to be able to participate in training? Yes. So let's say there's a holiday party. Does the employer have an obligation to accommodate an office holiday party? If it's office sponsored, yes, that is a benefit and privilege of employment. What do you think the benefit and privilege of employment is? Anyone? What's a benefit and privilege of attending an office holiday party? Exactly, team building, right? Exactly. Yes.
From the chat, we recently had a question if gender affirming bathrooms would ever be considered RA, wondering if it would be similar to the MS example in terms of stress exacerbation, morale.
That's an interesting question. I don't, I mean, I think it might be required by the law in terms of other laws, again, that apply to folks who are transgender or gender nonconforming. I think that we don't usually try to analyze those situations as a disability, and so I would try to avoid thinking in that kind of way, but they're required for other reasons, other legal reasons besides as a reasonable accommodation. So for that reason, I would avoid trying to think about it in that way, I think. But that definitely might be an obligation to provide those facilities anyway. Question in the back.
It seems to me like it would make more sense to try to cover that so as not to be offensive under RCW 4960 as sex discrimination if you're not providing equal access to a restroom.
So, and there actually are, the State Human Rights Commission has actually put out a WAC that talks about an employer's obligation to provide services for folks who are transgender or gender nonconforming. So it's even a little bit more specific than that in terms of what your obligations are as an employer. I don't know I think we did a presentation like that at the PMM a few months ago. And certainly if you have questions about what those obligations might be, we could talk about those for sure.
Yeah, it would not be considered a disability. However, like surgical procedures or something through that process would be considered a temporary disability. So we would have obligations to accommodate under this law if they were undergoing surgery or treatment.
Just like for anybody else. If they were
Correct.
having a medical procedure, you would treat that as a temporary disability. Correct. Or give them FEMLA or both. So.
What was the second part of that question? Something about stress?
And then it says, wondering if it would be similar to the MS example in terms of stress exacerbation.
So if the employee has a medical condition and the medical condition is being exacerbated by workplace stressors, then yes, we have obligations to accommodate. But stress in itself is not a disability, and there's no obligation to accommodate stress. Who doesn't get stressed in here, right?
Okay, are we good on that question? Robin, did you have your own question? You look like maybe you did for a moment.
My thought was the same as the person in the back,
Oh, okay.
actually, that there's another part of WLAD and the Human Rights Commission's taken a position that it's not a disability, but we still have an obligation to provide access to the same
When we're talking about
experience in the
bathroom
workplace
facilities,
Yes.
for people who are non-gender conforming or gender non-binary or trans. So.
And the person on the phone says, thank you, that helps.
Oh, good. Okay.
Perfect. Thank you. All right. So as far as requesting reasonable accommodations, so when I'm talking with managers and supervisors around the state, I tell them if they get nothing else from me from the training, but they get this part of it, when are you on notice, then I've done my job. The supervisor is on the front line. They're the ones that are interacting with the employee on a daily basis, and they're probably the first ones that are going to get information from the employee that there's a medical condition that limits work. So they need to know when they are on notice. The responsibilities are under the ADA. The employee specifically has to state they have a medical condition, and because of that medical condition, they need some form of adjustment at work. Under Washington state law, management just needs to be aware that the employee has a condition that may require a change at work. So we tell managers and supervisors, if you are aware that there's a medical condition and that medical condition limits work in some way, that triggers your obligation that you are now required to do something with that information. What I advise management to do is to have a private conversation with the employee and ask them, make them aware of the policy, make them aware of their right to request reasonable accommodation, and make an offer to them. Do you need a reasonable accommodation to be able to perform the job? And let the employee,
or even how can I help you?
and we do. We actually we train managers and supervisors, keep it safe. How can I help you? Right?
What would an example of that be? Like they don't come in with a doctor's note or something, but what would you notice about someone?
My wrists are killing me from keyboarding all day. Does that trigger our obligation to address reasonable accommodation? What two things do we have? My wrists are killing me and keyboarding. The employee has tied it to the job. That very case lost Boeing over $300,000. So when you become aware of a medical condition that limits work in some way, at least it triggers your obligation to at least have a conversation with the employee. Hey, you disclosed this to me. Do you feel you need a reasonable accommodation? Is there something that you need, or how can I help you? And again, having that conversation with the employee and then documenting that conversation. That's very important.
I was going to say, as the lawyer who kind of gets
Document
involved in
everything.
defending these decisions, sometimes I always like to see an email that says, yes, you did address it. Yes, this was the answer you got. And either, yes, you did follow through with something, or the employee said, nah, I'm fine.
And DSHS, we document everything, even phone conversations, we follow up in writing with them. So, and the requests from the employee do not have to be made by the actual individual employee. Who else could make requests for reasonable accommodations on behalf of the employee? Doctor, family member, a spouse, coworkers, right? You could get third-party notification. My advice is that if you do receive third-party notification, that you go back to the employee and you ask them, I became aware of this information. How can I help you? Do you need anything from me? And have that conversation with the employee. Because again, you're responsible for what you know. And if your knowledge is triggered by third party, I just always advise go back to your individual employee and you ask them, how can I help you? Do you need assistance? It doesn't need to be, they don't need to include medical terms or legal terms. The employee doesn't have to say, I have fibromyalgia, or I have cancer, or I have diabetes. They don't have to use medical terms. They don't have to use legal terms. They don't have to say, I need a reasonable accommodation. Reasonable accommodation is a legal term. Again, my wrists are killing me from keyboarding all day. We're now on notice. And we cannot require it to be in writing. I know DSHS, we do have a form and we do send it to the employee and asking them to complete it. But if the employee does not choose to complete the form, we still proceed with the process. As far as interactive process, again, once you're on notice that the employee has a medical condition and that medical condition limits work, we advise that that initiates a conversation with the employee. How can I help you? Do you need assistance? If the employee says, yes, I need assistance, follow up in writing to them. You can get HR involved. What I tell managers and supervisors is that if you ask the employee, how can I help you? Don't ask about what their condition is. Don't ask for medical information. You can ask the question, how can I help you? If the employee says, well, I need an adjusted schedule because of my medications, it's affecting me in the morning. And so if I can come in later in the morning and work later, so an adjustment to my work schedule, if you would do that same accommodation for a similarly situated employee so that they could wait at the bus stop for, with their children in the morning, and you would adjust their schedule for reasons outside of disability, don't make the person with a disability jump through hoops to get that same benefit and privilege. Again, how can I help you? I just need an adjustment to my work schedule. And if it's something that they can do, then great. We're not going to get sued for saying yes. Say yes. But if we tell managers and supervisors, just don't say no. Call your specialist first. Call your reasonable accommodation specialist first. Because we have to have a defense if we say no. So if the employee says, yes, I have a medical condition, that medical condition's limiting work, and we make an offer of reasonable accommodation and they say no, document that. Document it back. And I love emails because emails have a date stamp and they're discoverable. I mean, if you need to pull that up in the future for any reason, you're able to do that. But follow up in writing with the employee, just a friendly email, just letting them know you made me aware of this. I offered you reasonable accommodation. You didn't want to consider it at this time. If you change your mind and want to pursue it in the future, let me know. And it just documents that you met your obligation. You were on notice, you offered. The employee has a right to say no. But if the employee says yes, now that triggers the interactive process. And I can talk about what DSHS's process looks like. It might look a little bit different. DSHS gets close to 1,000 cases. We're averaging about 980 something cases a year in DSHS. So we have volume that we deal with. So our process is based on volume. But again, the first thing, we have an online form that the supervisor can complete, the HR consultant can complete, or the employee can complete. the loss prevention consultant can also complete the form as well. So, so we have this online intake form. Once we receive the intake form, that case is now open and assigned to one of the specialists based on the areas that they cover. The first thing that the specialist is going to do is they're going to review medical. They're going to review what has the employee already provided. We're not going to go out and seek medical for information we already have. So the specialist is going to review medical. If there's a need, if the medical isn't sufficient, because those of you know that a lot of times when you get medical statements from a doctor, they're insufficient. The doctor says, give my patient this, but the doctor's not explaining that they have a disability. The doctor's not explaining what are the limitations of the condition. So it helps you understand what it is the employee is asking for. So if the medical is insufficient or we don't have medical, sufficient medical, we will go ahead and seek that information. One of my specialists will go ahead and seek that information and working through the employee. We send the medical questionnaire to the employee. The employee will take that to their doctor to complete and return to us. And we put every step in our process has a timeline to keep it moving forward. So once we have the medical information, that we normally schedule a meeting. In some cases, if the appointing authority is willing to provide the employee what they're asking for and the medical supports it, we're not going to have a meeting just to tell the employee, we're going to give you what you asked for, you know, because we're busy. So if the appointing authority is willing to say yes to it, then we go ahead and we document a letter for their signature to the employee approving the accommodation, and we close out our case at that point. But in most cases, it requires an interactive meeting. So we schedule an IRAP meeting with the employee, with management, with HR, and we get together and we have the conversation. The purpose of that conversation is to identify workplace barriers and to assess the employee's abilities to be able to perform the job. Identify possible accommodations and evaluate each for effectiveness. The employer's obligation is to provide an effective accommodation. Effective meaning that it meets the needs of the employee and it also meets their business needs. It allows them that equal opportunity to perform the essential functions of the job on the same level as any similarly situated employee. If more than one effective accommodation exists, we do take into consideration the preference of the employee, but the employer makes the final decision as to what accommodation is put in place. Again, it has to be effective, removing the barrier to allow the employee to perform the job. So normally that's where our process ends. During that conversation, we identify effective accommodations. We offer the accommodation to the employee, and we document it as we document our meeting, document the accommodation. If it's temporary, we document the timeline of that temporary accommodation. If it's something long-term permanent, we also would document that as well. And then at that time, we would go ahead and put the accommodation in place and then close out our case. If unable to accommodate the employee in their current position, so there is no accommodation that we could provide the employee to allow them to perform the essential functions of their job, then the employee is not considered a qualified person with a disability. We would move to the next step in the process, which is reassignment to an alternative position. Any questions?
Oh, Robin has the microphone.
I was just wondering if you could describe what documentation is kept with your office versus what documentation stays with the supervisor. You gave an example of if the supervisor would accommodate someone for their kids at the bus stop, adjusting that schedule. Do you have any sort of interaction where where the supervisor provides that to your office, or is it separate and kept in a supervisor file?
So you're talking about the documentation?
Yeah, just
okay.
your documentation.
Because
process.
we tell supervisors, you don't touch medical, you don't ask for medical, stay away from medical, and you don't keep medical. Because again, a lot of times the employee hands the medical off to their supervisor. There's no harm, no foul with the supervisor accepting the medical. We just tell them, don't hold on to it, don't make a copy of it, get it to HR, get it off your plate as quick as possible. But don't ask for it. We just tell them, don't seek it. So When we do seek the medical, we don't share it with the supervisor. We share it with the appointing authority who has decision-making authority for DSHS.
So the friendly email that says, yes, we'll accommodate you, who keeps that?
Well, if it's a benefit and privilege of employee and they're giving it to other folks for reasons outside of disability, we wouldn't need a record of that. So again, that's just something that they would grant to anyone. So it wouldn't necessarily be considered a reasonable accommodation. If the employee requests something of their supervisor and the supervisor is just willing to grant it to them, again, we would not document that as an accommodation because we're not involved. We keep the agency's records of reasonable accommodation. We're not involved in all reasonable accommodations for DSHS. I will say that out front. We don't have enough resources to do that. The ones that we get involved in are the ones where a lot of times where management's already been working with the employee and nothing has been successful. So then they reach out to us saying, we need your help, and then we facilitate from there. So, but we do keep all of the records. They don't have to keep any of the records. For DSHS, literally all they have to do is just show up and make decisions. I think one more person had a question behind her.
When you have that interactive meeting with the supervisor, the employee, and HR, and you're talking about reasonable accommodation, I'm assuming those conversations just include the restrictions
Correct.
that the employee has.
Correct.
Okay.
Now, again, each of my specialists know we don't discuss the nature of the condition. We have that, but we don't discuss that during the meeting. A lot of times the employee will bring it up. And again, a lot of times they've already told their supervisor everything that's going on with them. And again, that's fine. We just tell them, keep it confidential, protect the information, don't disclose it. You know, don't discuss it with their coworkers or anyone else. But when we're in the interactive process, our focus is now, here are your limitations and barriers to work and how can we accommodate you? What are some effective accommodations? That's the focus of the conversation. Okay. Do you want to do this one or it's up to you?
I can.
Okay.
So we talked a little bit about collective bargaining agreements and how they might impact reasonable accommodation. And as I said earlier, every CBA that you're going to find is probably going to have an article in it. And I know all the ones that we deal with through LRO, all of them have an article about reasonable accommodation, and usually also disability separation is included in that article. What it has to do is comply with state and federal law, any article in a CBA. Of course, that's true of just about any article in a CBA, whether it's reasonable accommodation or not. It should comply with the governor's executive orders. So the decisions to disability separate, well,
Actually, any decision.
any decision along the reasonable accommodation process could be grieved as a violation of the contract if you haven't, I suppose, followed the interactive process. I'm not aware of any grievances that we've had in the state that have to do with failing to follow the reasonable accommodation process. I am only aware of grievances that we've had that have gone to hearing that deal with disability separations. Do you have something to say, Robin? You look like you do.
I mean, I filed some, but
Yeah.
they never got to arbitration, right? Because a lot of times the remedy to a low-level grievance, when you're saying the reasonable accommodation process hasn't been followed, is start following it. Let's have that meeting. Let's start having the interactive discussion. So,
Which if
it's
they
not-
would ever have asked me, I would have told them to do just that.
like it gets like this does get some action in the grievance process, but I think you get it worked out at the lower levels because it's pretty obvious what the solution is if there's a concern about the process.
Right.
Yeah, we've only, in the last 20 years that I've been doing this, we've only had one case make it to arbitration, and that was last year. It was a case that Laura actually defended for
And
us.
Connie testified on very
And,
eloquently.
And
actually.
we did win that case. It was a disability separation, and we did win that case because, you know, again, the employer is not obligated to grant lengthy or indefinite leave, and which is what was the case on that. But yeah, we don't get a lot of grievances on those because we do. I tell my staff, you work every case with the expectation that the employee is going to challenge it and you're going to be defending that case. So everything in that file is going to defend your case. And so we don't get a lot of grievances on the RA process.
We do have some sort of time limits. In the WFC contract, it says start the process within 30 days. You know, you should do it what's a reasonable amount of time, right? So somebody can't necessarily wait for 30 days for you to start processing their request. So in fact, you know, I mean, if it's more urgent, you probably need to get on it a little bit sooner even than that. In these cases of grievances under contracts, the union is the exclusive bargaining representative for violations of the contract or disability separations. However, you might imagine that attorneys often get involved in these disability discrimination cases kind of earlier sometimes than they might in other situations. I think that unlike in a disciplinary process, right, where we say truly the union is the exclusive bargaining rep and you have to either have the union come and represent the employee, or the union has to specifically say we're not going to represent this employee, we're deferring to their attorney, so you know it's okay, go ahead. In a disciplinary context. In the reasonable accommodation process, it's a little bit less formalistic usually than that, because it really is an interactive process and you're trying to get whoever to the table can help kind of sort out the situation so that we hopefully get to an effective accommodation. And so while attorneys may often come to, or sometimes, not often, come to an interactive process, the expectation is that they don't, like attorneys are often want to do, take over the process. The idea is that they would just sit and listen and be a support to their client. And I don't think we usually have problems with attorneys stepping out of line in terms of attending those processes. And I don't believe we've had any issues with the unions if attorneys do come to those meetings.
When we're scheduling a meeting or initiating the process, we always make represented employees understand that they have a right to representation during the process. So that is sent to them in email, and we notify them, you know, that you have a right to representation if you choose to have it there, but they have to make the arrangements for that. And we let the employee know that. You all remember the Janus decision last year. A lot of employees in DSHS felt that the Janus decision meant that they now get to choose their representative, that they get to waive their union representation and they get to have their attorney there to represent them. And so we've had to correct their understanding that, you know, you're still in a represented position. It's still represented by the contract. And if you choose not to have representation there, your attorney does not get to represent you in the meetings. Now, we will not, because we do have some employees that say, I will not meet with you unless my attorney is present. I'm not going to miss out on an opportunity to engage in an interactive process with an employee because they want their attorney there. But what we do is we do shut down the attorney at the very beginning of the meeting when we're doing introductions and everything, and just let them know that, the union is the exclusive representative for the individual, and that we're allowing them to be there, but their role is as observer only. And we most of the time they don't challenge that. We've only had a couple of attorneys that wanted to challenge that, but for the most part they sit there and they're very quiet, so it's fine.
I wouldn't tell you no.
I know. I know you would.
If I was the attorney sitting there, I'd be quiet. I mean, just as an overview though, so I mean, usually these kinds of cases, if we fail to accommodate someone or discriminated against them because of a disability, it's most likely that they're going to end up in litigation, if that's, where it's headed, like a tort claim, like a lawsuit, like a very unpleasant process. Have you ever had to witness on one of those?
With an attorney?
Well, in a lawsuit?
Mm-mm.
That's because your cases always get resolved appropriately. But I know that there are reasonable accommodation specialists in the state that have had to be witnesses in lawsuits and trying to explain the process and what you did and why you didn't do this or what have you. It's fairly unusual for disability, except for disability separations. Two that I can think of in 20 years that have gone to an arbitration. Mostly, like I said, it goes to some sort of tort claim and lawsuit in these cases. Want to talk about that one?
Can you speak to having other supports in the room, such as a family member or a close friend?
Yeah, we are very open to having, the employee can have anyone there that they want, really. The issue is more of the matter of who represents them. And employees that are not represented under the contract can bring their attorneys with them. And we've not had any issues with attorneys because, again, our conversation, our process doesn't change regardless of who's in the room. You know, our focus is always, how can we help you? How can we help you do your job? And so it's, but again, these are some very difficult, hard conversations that we're having with employees. So if they want to bring their spouse, especially employees who have some very severe situations going on in their life, some very severe limitations, and they're potentially looking at a disability SEP, we want a family member there, a spouse there, that's going to help them make decisions and help and ask questions that they may not even think about, because again, there's a life beyond DSHS. DSHS is a job that they have that pays bills, you know, their mortgage, their families, you know, raising children. And you know, we want to make sure that they have all the information that they need to be able to make informed decisions. And having a family member or a supportive person there is going to really help in that process. We don't let them take over the meeting. That's only happened like once or twice.
I mean, because spouses can have their own points of view too, and sometimes they're not, maybe they might not be helpful, but again, that's just managing the process and the expectations in the room, because Connie does get through the process, and that's important to do.
Cool. All right, so disability separations. So there are a couple of agency-initiated or employer-initiated disability separations. The most common one for DSHS is that we were unable to accommodate the employee in their current position or accommodate them into an alternative position. And that process is well documented. So if we've exhausted our process and we were not able to accommodate the employee, we would initiate a disability separation. My staff know very well that I tell them an employee is never blindsided in this process. If we reach a disability separation decision, they know it's coming. They know the disability separation is coming. Our first meeting with the employee, we cover the entire process. We have a spiel that we go through, that we cover. Here's what our first obligation lies, is to accommodate you in your current position. But if that's unsuccessful, here's what we can consider alternative positions. If the ability to accommodate you into an alternative position is unsuccessful, the agency will initiate a disability separation, and I explain what that looks like, or the specialist explains what that looks like. So that conversation happens early on. So as we're walking down the process, if we are getting to disability separation, the employee knows it. And we keep them informed as part of the entire process so that they're not blindsided. The other one is a medical separation. So the doctor provides a medical statement stating that the employee is unable to work in any capacity and leave would not be effective. So those are both agency-initiated disability separations. I review all disability separation actions for DSHS. So if the reasonable accommodation specialist is working a case and it gets to a disability SEP action, they complete all the paperwork, the disability separation, the chronology, all that information that goes with it, and they send it to me for review. I'm reviewing it to make sure that process was followed correctly, that there was a meeting with the employee early on, and that, you know, the first meeting with the employee wasn't like, hey, we're disability separating you. So that's always the goal. But again, I'm reviewing it to ensure that our obligations have been met and the case is solid. Then if it's approved, then we send it to the appointing authority for them to take the action. So the other disability separation is voluntary, and that's when the employee requests the action be taken. DSHS, we do require that the employee submit their request in writing so that there's no misunderstanding as far as what they're asking for. We do ask for it in writing. We do have to have some form of medical verifying that the employee has a medical condition and that medical condition limits work in some way. We do acknowledge receipt. We draft that paperwork for the appointing authority for them to sign and approve it. And if the employee is requesting the voluntary disability separation, there is no obligation to address reasonable accommodations in the current position. Under the some of the contracts, the effective date of a voluntary disability separation is effective immediately. However, we allow the employee and the appointing authority to negotiate what that date is. So we tell the employee, unless you want to designate or you want to work with the appointing authority on a date, we're going to assume that this is effective immediately. But in most cases, the employee wants that additional time for medical benefits to ensure coverage through the end of the month or the end of the next month or something, so they'll want to negotiate an end date and exit date. So we let them do that. And voluntary disability separations cannot be challenged. Agency-initiated separations can be challenged. Any questions about disability separation? Hold on one second for the...
So you stated that when a statement comes forward stating that the employee is unable to perform the current job or any other job in any capacity, is that stated in the law as well, that we could do a medical separation?
So the question becomes that if the employee is not able to work in any capacity, and so leave will not be effective. We always look leave as a form of accommodation. But normally in these cases, the employee's already been out on leave. They've exhausted their FMLA. They've already been out on some reasonable accommodation. But the doctor, so when we go back and we seek, once they exhaust the FMLA, we go back and we seek updated medical. What's their status? What's their prognosis? Are they going to be able to return to work? And if so, when? If the doctor is not able to provide us that information or any predictability, if the doctor says it's indefinite, there's no obligation to grant indefinite leave or lengthy leave. So if the doctor says, oh, they need another year of leave, we're going to be meeting with the employee and we're going to be asking them, can we accommodate you to return to work? And if the answer to that is no, we would be looking at initiating a disability separation.
The kind of gold standard for that is if you get a note from a doctor that says, Laura cannot work for the foreseeable future in any capacity, then you're kind of at that place, right? You need to make sure that, you didn't get that note because a manager asked the doctor to give you a note that says that, which is what happened to us on our disability separation grievance arbitration that we had. And it felt like the person sort of got tricked into providing that information. On the other hand, it turns out, writing the briefs, that there's good case law that says if your doctor says that, we assume that your doctor is providing a medical opinion, and whether it feels like the employee got tricked or not into asking the doctor for that, we assume that the doctor is giving a legitimate medical opinion.
But that should still trigger a conversation. It should still trigger a meeting with the employee, because the employee may not understand that they have rights to reassignment. So it's really important that you meet with the employee, you explain to them what the process is, what their rights are under the process, and you have that conversation with them and explain to them, about, that if the doctor's saying indefinite leave and they're not going to be able to return to work, we have that conversation with them about disability separation. We allow them to ask any questions they have. What does this mean? What are my rights beyond disability separation? And we cover all of that with the employee and answer all of their questions. So again, they know the action is coming. They don't just get a letter in the mail going, hey, your exit date's on this date.
The thing about Connie and her process and what I've observed and how she does it is that she's very humane about it. And that's really important in these situations. Because you might imagine, if you're someone who's got cancer or some other kind of terminal disease and you're in the worst place in your life and your job is important, but getting your benefits and your medical paid is kind of important too. So, you're struggling with a lot of different stresses and problems that are coming up all at the same time. And, bringing humanity to that process is it's really important just because it's a good way to do it. I mean, it also makes it more legally defensible, of course, as the lawyer, I would tell you. But at the bottom, you know, at the end of the day, I mean, they're your employee, and and you want to treat them with respect and as much compassion as you can as you stay with the process and go through it. So you have a question?
So for the department initiated, they have to be deemed unable to do the work in any capacity, any job?
No. Under the first one, if we're not able to accommodate them to perform the essential functions of their permanent position, then we move the case to reassignment, and we begin the process of looking for alternative positions within the agency that the employee could perform. If that process is unsuccessful, then we can initiate a disability separation.
So in the voluntary, it just says the medical says they're unable to do their present job, and then
Yeah.
they're separated. So
That there's some barrier.
we're then not obligated to look for reassignment?
No, not for voluntary, because the employee is asking for the action. We would just take the action. It waives your responsibility of even addressing reasonable accommodation. So even if, and we had a situation one time where the employee provided a medical statement and the doctor said she would be fully released, full release, no restrictions in 4 weeks. She requested a voluntary disability SEP, and I'm like, you realize we can't accommodate 4 weeks of leave, right? You're aware that we can do this. And she said, yeah, I'm aware of it, but we were able to accept that. It releases us of our obligation to grant the 4 weeks of leave, and we just initiated because it's her request. It's not an action that we took. But we do request it in writing.
Other questions before we move on in the back?
It's not really a question, but just a statement that I think fits in really well here is that you don't have to create a job for them if they are not voluntarily leaving.
That's true.
Yep. And we do have a slide on reassignment, so
Yeah.
we'll get into that more detail. So, great.
Okay. Any questions online? Okay.
So due to time constraints, we'll kind of go through this really quickly as far as what medical information can an employer seek. As a general rule, an employer can ask disability-related questions or seek medical information, but it has to be job-related and consistent with business necessity. Under the pre-offer, as far as what an employer can seek, you're prohibited from asking any questions about the existence of a disability or to solicit any information that would disclose that information. So never ask any questions that would solicit that information. Now, in the pre-offer, which is usually the recruitment and application process, the exceptions to asking for information is if the applicant or individual seeking employment asks for a reasonable accommodation. Obviously, if they ask for a reasonable accommodation, we could seek medical, or we would go ahead and just provide the accommodation that they're asking. What I tell managers and supervisors in this process when I'm doing training is, if you reach out to an incumbent that, to schedule an interview and they request a reasonable accommodation, do not engage them in a conversation. Defer to HR. Just let them know, I'm going to have HR contact you. They're going to let me know what you need. So take yourself out of that position, because if you're going to be making a decision on who you're going to hire, you don't want access to information. You don't want access to that information. So the other exception is if the individual self-discloses that they have a disability. Again, I tell managers and supervisors, if they bring it up, like during the interview process, when you ask them, give me a strength and a weakness, and they say their weakness is, and they start disclosing information about a medical condition, do not ask questions. Don't dig deeper. Don't ask additional questions about that information. Just move on to your next question. Or the disability is obvious. Now, the law does state, so for example, if you have an interview panel and somebody walks in, they're escorted in, they have a seeing eye dog, they sit down, you're probably going to have some questions about how they would perform certain aspects of the job. The law does state that you can ask questions, but they have to be job related and consistent with business necessity. All hiring decisions should be based on their qualifications for their position, not whether or not they can perform the job with or without an accommodation.
In that example, Connie, of someone coming in with a seeing eye dog, can you give an example of what a question might be related to their ability to perform the job if you have this sort of evidence that they may need accommodation?
So for example, if the job, and I'm speaking for DSHS because those are the jobs I know. So if you have an employee who, or if you're recruiting for a position where this position is required to go into to individuals' homes and do health and safety checks, you could ask a question. This position does require you to go into homes, observe, look, for mainly for adults because we lost children's, but for adults, looking to ensure that, they're being cared for, no bruising, those types of things. How would you perform that? I mean, could you explain to me how you would perform that? So you could ask for them to kind of explain that. Any questions?
The one other thing I might add about this, especially in the pre-offer stage, people that do reference checks also cannot ask questions that would elicit medical information about a particular candidate.
Exactly.
Like, how often was Laura out sick last year anyway? Those kind of things, you don't want to have your managers ask those kind of questions.
Exactly. So post-offer. Post-offer is a job offer has been made, they've accepted, but they haven't started yet. Unlimited restrictions. You can ask at this point, do you need a reasonable accommodation to perform the job? If they say yes, oops, sorry, post-offer. Thank you. You can ask at this stage, do you need a reasonable accommodation? We tell managers and supervisors if they need something, they're gonna let you know. So, I mean, don't ask, don't just assume that somebody's going to need something unless they have an obvious disability. Then if they have an obvious disability, you can ask them at this stage.
How often do you do conditional job offers?
Usually they're conditioned on passing a background check with DSHS. So those are usually situations where we're waiting for.
And if you were going to ask these questions, though, you would have to ask the same questions of every candidate,
in
right?
that job class. Yep.
So you can't just ask about one person or one person.
So in the post-offer stage, if you do address a reasonable accommodation, if the individual requests an accommodation and you go through the process and you've made a determination that you're not able to accommodate the employee to perform the essential functions of the job, again, if you end up rescinding that job offer, you have the burden of demonstrating that rescinding the job offer was job-related and consistent with business necessity and that the candidate could not be accommodated in the position. I know in the last 20 years we've been doing this. I'm only aware of 3 times where we've done that in DSHS. And we've went through our complete process. And they've been mainly in the 24/7 facilities, and we were not able to accommodate them. And that process, again, is well documented because even though they haven't really started the job yet, if we're rescinding an offer, it's an adverse employment action that you have to defend if they challenge it.
I think of the conditional job offer as being a lot in like people that have law enforcement, folks that work in their agency. It's less used in just like an office job setting, which is what most agencies have.
A lot of positions in DSHS have required background checks because they work with the vulnerable clients in DSHS. So employment. Now the employee has started, they're in the job. We're back to general prohibition. Do not ask questions that would solicit information regarding their disability. Exceptions are they request an accommodation. Now, if the employee is requesting an accommodation, if the disability is not obvious and the need for the accommodation is not obvious, we can require medical information. And I know DSHS does require medical if it's not obvious. If you have objective information to support a reasonable belief that the employee has a disability that needs an accommodation, on those situations, again, I tell managers, if you have objective information that there's a medical condition going on and there's a limit to work, meet privately with the employee and make an offer of reasonable accommodation. We're not just going to openly just start requesting medical, requiring that they provide medical. Or the last bullet is objective information exists to support a reasonable belief that due to a disability, the employee poses a direct threat to the health and safety of others. The exceptions are if, for the first two bullets, they request an accommodation or there's an obvious medical issue going on at work. We can meet with the employee. The employee has a right to say, no, thank you. I do not want to pursue a reasonable accommodation. However, for direct threat, if the employee states, no, I do not want to participate in the direct threat analysis, and we have objective information to support that reasonable belief that there's a possibility of a direct threat. If the employee says no to that, we're going to assume that the threat exists and we're going to take action at that point. The purpose of seeking medical information, again, is to verify that the employee has a disability claimed and that their disability necessitates an accommodation in the workplace. Any questions? Yes, I do. I had a case that I worked many, many years ago. We hired a nurse at one of the institutions. Before she started the job, she had requested an accommodation. She stated that she was dyslexic and that you probably remember this because I think you were the one that was advising us, but, and she stated that she required all policies and procedures in audio format versus written format. Remember it now? So we were moving forward and providing her with that. Well, then I got a phone call a few days later from the appointing authority, and supervisor and HR were in the office. And so they called me and they said, as they were going around showing her the rounds, the nurse, because she'd started and she was doing rounds and stuff, she was giving the wrong medication to the juveniles. It was a juvenile institution. She was giving the wrong medications out and the wrong dosage out. She was also observed reading the testing incorrectly and logging it incorrectly. There is a nexus there to dyslexia. So we met with her. I explained to her, the union was involved. She had her union rep and everything involved. And we scheduled a meeting. I explained to her, when I was on the phone call with management, I explained to them, as soon as you hang up this phone call, pull her off providing direct patient care immediately. So they did. They put her on alternative assignment. We met with her. We explained to her what was going on. We answered all her questions and everything. We asked her to work with us to seek the information regarding the direct threat. She was not happy, but we asked her, she seemed to think that there was no correlation to her disability. And I said, well, work with us and have a doctor tell us that. We're okay with that, but we just need a professional to tell us that. So she agreed to participate. She showed up to the doctor's appointment. The IME doctor had put some forms in front of her to sign so he could do testing and release the results of the testing to us. She refused and walked out. I got a phone call the next morning. One was from the doctor saying she walked out, she refused to cooperate. The next phone call was from the union rep saying, I talked to her, she's going to cooperate, reschedule the meeting, she'll work with you. So I went ahead in good faith working with her and I rescheduled the appointment. Exact same thing happened. So my next conversation with her is, you no longer qualify for your nursing position. And so we move forward with that.
Just keep in mind, as Connie's going to go through the actual direct threat analysis kind of briefly, but just keep in mind when a manager comes to you and says, Laura's about to go postal, or she's really behaving weirdly and we're afraid, everyone's afraid, that doesn't necessarily mean you have a direct threat. I'm just saying. Think about that as we go through the analysis. Because I think I've had like maybe 6, I'm pretty sure on 2 hands I can count the number of times we've done a direct threat through to the end in the 20 years I've been doing this.
We've done several direct threat analysis, but most of them were not real direct threat analysis. They were based on threats of violence, which again, I have feelings about that, but that's now changed. But, we now treat threats of violence through the just cause process. We do our investigation. It's treated as a performance problem. But the few that we've done, I'd say we do about a couple a year.
Really?
With DSHS, yeah.
You don't call me anymore.
We got this down now. So, but yeah, most times it doesn't, they don't pose a direct threat to the health and safety of self or others. So it's not an issue. So very rare we get one where it's like, yes. So, all right. So as far as direct threat goes, as you can see, the EEOC defines it as a significant risk of substantial harm to the health and safety of the individual or others that cannot be eliminated or reduced by reasonable accommodation. So when we go out for direct threat analysis, I always ask the employee first if they're working with a specialist in their field. If they're working with an ARNP or a chiropractor, we're not going to go out for direct threat with those doctors. We go out for a specialist in the field. So if they aren't seeing a specialist, then we ask them to participate in the IME. We're seeking a specialist in that field because, again, we're looking for doctors with higher credentials than their doctor who's treating them in order to make that analysis. So we send information about the job, we send information about what we've observed or any information we have regarding the disability. But we also include information regarding the duration of the risk, the nature and severity, the likelihood that the potential harm will occur, and the imminence of the potential harm. So these are all questions that we do ask the IME doctor. But again, the whole purpose of going out for the IME is not to get rid of the employee, it's to gather information on, can we eliminate the risk? And that's the whole intent of seeking the medical information. Can we accommodate the employee to provide them something that would remove or eliminate that risk? Do you have anything you want to add to that? Nope. Okay. Any questions? Independent medical exams. So independent medical exams, for DSHS, there has to be a reason to go out for an IME. Usually we always work with the employee and their doctor, whoever is treating them. As long as they're a qualified healthcare professional, which means qualified to diagnose and treat condition, we will work with the doctor, their doctor. However, if the doctor is not providing us, so we go out and we seek medical information and the doctor is not answering our questions. For example, I had a doctor one time where we drafted some specific questions to the doctor and the doctor came back with every single one of our questions, needs a new supervisor, needs a compatible supervisor. Well, who doesn't, right? So, so what we did was we told her, okay, so your doctor's not being objective here, so we're going to send you out for an IME. So we did. So that was one reason to do that. The other one is normally it's a direct threat. Or the second one there, objective evidence exists that there may be a need to provide reasonable accommodation. Normally we work again through the employee's doctor. If the employee says no for maybe their doctor is not providing sufficient information and we're not getting the information we need to be able to do the analysis, or if the employee says that, nope, I'm not going to go to my doctor and I'm not going to provide you the information, that ends the process there. They're expected to perform the job without reasonable accommodation. If the employee says no to the direct threat analysis, we're going to assume the threat exists and we're going to take action at that point. We do explain to the employee, though, if they refuse to participate in that direct threat analysis, that IME, then we explain to them, you do understand by refusing to work with us to gather the information we need to make this determination, we're going to err on the side of caution. We're going to assume the threat exists and we're going to take action, which means we're going to take you out of your position. You're no longer going to qualify. And in some cases that changes their mind. In some cases it does not. So. Any questions about independent medical exams? I will say this, they are ridiculously expensive. We're sending an employee out. We've already sent her out for 2. She just attended the last one, I think it was yesterday or the day before. And the 2 IMEs that she attended previously, both totaled up to $16,000 for 2 IMEs. That's not even including the one she attended a couple of days ago. So we're waiting for the bill on that one. So they are expensive, so just be prepared. Yes.
I was just curious on your take on the IMEs when you're addressing that. How often do you get Do you ask for a panel, or do you try to keep it limited for cost reasons to one doctor? How do you make that determination?
It depends on how many disabilities you're looking at. Because again, you want a specialist in the field. So for this one employee, she had 4 disabilities, all different: mental health, physical, and neurological. So there was one doctor, it was a neurologist, that was able to do 2 of her conditions. Then we had the other doctor do the other one, and then we had to hire, a psychiatrist for the mental health issue. So it just depends on how many disabilities you're looking at, because again, you want to hire somebody with a specialty in that field. Sorry, I'm gonna let you cover Gina.
Oh, you are?
Oh, hold on, one more.
So, oh, sorry, go ahead.
Oh, I was just wondering if you send a questionnaire to a provider and they're providing conflicting information within the questionnaire, is that the appropriate time to go down the process of maybe looking into getting an IME?
I mean, that is an option. I mean, if you have a doctor that is telling you one thing and the employee is doing another thing, you're observing something completely different, you can go out and seek an IME. I mean, you could, or you can accept what the doctor is stating and hold the accountable to what their doctor is stating.
I'm referring more specifically to when the doctor, like you ask a few different questions and in one answer they're saying one thing and then it contradicts.
Oh, so they contradict?
Yeah.
So usually we go back to the doctor and we ask the doctor saying, okay, you answered this on this, you answered this on this. Can you please explain the differences? So we'll draft another set of very specific questions, basically telling the doctor, you contradicted yourself. Can you please answer these questions?
Okay, but if it continues, is that the point when you...
Then you could be looking at an IME.
Thank you.
You're not getting sufficient information.
I had something that you mentioned before is that you referred to a case where a supervisor or manager had talked to the doctor and kind of nudged the doctor to give specific medical advice. Seems like the whole premise of that situation is off, because the manager shouldn't be talking directly to a doctor. That should be going through reasonable accommodation.
Actually, this was not, they never talked to the doctor. It was a situation where, again,
They
this is
suggested
hearsay.
to the employee.
The employee had said, well, what do I need to do to be disability separated? And the specialist said, well, your doctor needs to say that you're unable to work for the foreseeable future, something like that. So the employee went back to the doctor and the doctor wrote exactly that statement. And she brought it back and she was separated. And she challenged it saying, wait a minute, you told me to have my doctor write this and my doctor wrote it, and now you separating me? So
she didn't really, I don't think she understood what being disability separated meant exactly.
Yeah.
It got really confusing. And I mean, to me, the lesson of that case was follow the process, talk to the employee, have an interactive process. And also, I mean, sometimes we wonder if, doctors just write down whatever their patients ask them to write down. In that case, it kind of sort of seemed like maybe she had. But again, I would just say that the case law says if the doctor writes it, we assume that it's their medical opinion.
Yeah, because I will say we don't talk with doctors. I mean, we don't. All of our communication with doctors are in writing. And we tell managers and supervisors better not be calling doctors. Now, we do allow HR to contact doctors to verify, because sometimes we'll get a medical statement and it looks like it's been tampered with. And you can go back to the doctor. You're not asking for any additional medical. You're just asking doctor, can you verify that these are your responses to these questions?
Yeah,
and if so,
you'd be
initial.
surprised.
And if so, can you initial? Because we've caught employees tampering with medical. So
yes, we have.
Right.
Okay, we're going to go on to Gina. So in 2008, the Congress passed this Title II, which requires that we not discriminate against people because of genetic information. So it prohibits employers from asking for genetic information in any form or fashion. And you can see the definition here that you'll get later on about what constitutes genetic information. I would also say that I'm pretty sure, I don't know if you all do this on your medical questionnaires, but we actually have a little paragraph that says, doctor, don't give us any genetic information. We don't want it. And if you have that on there and you get the information anyway, it protects you from violating the statute.
Yeah, we include it on all of our medical inquiries. Me and my staff do.
Okay. Do you want to do confidential information or what?
Sure. You want to do it?
Okay, confidential information. Disability related information includes anything you get from a healthcare professional. So it could be, doctors, nurses, physical therapists, other healthcare providers, right? Information that is volunteered by the employee or the applicant, and any information about the reasonable accommodation process. That's all confidential. And as we talked about before, we don't give that information to supervisors. We ask them not to keep any kind of medical information. Even like you're released to return to work note from a doctor, even if they're not doing reasonable accommodation, really should go to HR and be put in their medical file, not be left in their supervisor's file to be found later on by some poor unsuspecting attorney who's doing discovery and finds that the supervisor's keeping medical information in their supervisor's file, which is not a good idea. So the appointed authority gets access to it. You have to maintain the medical information in a secure manner apart from personnel and supervisory files. And you can only disseminate confidential information on a need-to-know basis. So it really is serious that you not release confidential information beyond the folks that need to know. And generally that's the appointing authority and the reasonable accommodation specialist and probably the HR person working on the case. I think this comes out of a CFR, this chart that we have next. So the supervisor needs to know about restrictions on work duties and provisions of reasonable accommodation, right? So if they can't lift more than 20 pounds or something, the supervisor needs to know, but they don't need to know it's because they have a broken back or whatever the reason is, right? Sometimes first aid folks will get some sorts of information about treating somebody with a disability or if you need to evacuate someone. And of course, government investigators get whatever they want because we're the government.
And the AG's office too.
And that's too. Yeah, that's true. Actually, with your lawyer, you can share with your lawyer.
Go ahead. I get a lot of calls from the AG's office. Well, I don't say a lot because we don't get challenged a lot, but when we do, we get calls saying, do you have any records on this employee? So we turn those over. So qualified individual with a disability is also a legal term. And basically what it means is that they already satisfy all the skills, ability, education, experience, whatever the qualifying criteria of the job. And they have to be able to perform the essential functions of the job with or without a reasonable accommodation. If the employee meets all the skills, ability, education, experience for the job, but they're not able to perform the job either with or without an accommodation, they are not qualified. They're not considered a qualified person with a disability. You are not required to hire or maintain employment of a person who is not qualified. Any questions? That's normally when a case moves to reassignment. They are not qualified for their job because they can't be accommodated.
We're not going to change the essential functions, as somebody already pointed out. We're not going to create a job for them.
Correct.
But first we have to figure out what the essential function is. How do we do that?
So these are just a few slides that we got with management. And again, this is a full day conference and we've got like 25 minutes left. So the essential functions of the job really determines what the job is, not how it's performed. One of the things that I will caution you guys on is that we had a situation, and Robin was involved in this one, but we had a situation on a position where the individual had been performing the job for years. He was the only one that carried that specific job class in his office where he worked. His responsibilities were maintaining the motor pool cars. So he made sure that they were kept full of gas, that they were cleaned, that they had all the maintenance, tires, all that stuff, oil changes. That was his responsibility. And he'd been doing it for years. He goes out on a medical leave of absence, and when he returns to work, he provides a medical statement saying, I can no longer drive a motor vehicle. So he was restricted from driving at all. And the appointing authority is like, that's an essential part of his job, that, he's required to do this. I mean, he's been doing it for years. It's in his performance evaluations, and there's no one else available to do it. Well, my specialist who was working the case for this one called me and said, we have a problem. There's nothing in the job description in the PDF that states that this guy has to drive motor pool cars or he's required to do this. And so we had a conversation with the appointing authority who insisted it is an essential function of the job. And so we told him, it's an uphill battle for you, but you'll need to be able to defend that. And he felt that he had adequate information to be able to defend that case. So a determination was made that the employee didn't qualify. We moved his case to reassignment, and we found a lateral position, same pay, that was offered to him, and he said no, he declined it. So his case was moved to disability separation. He was separated, and he promptly filed a grievance. So in that grievance process, as it was going up, the labor relations specialist for DSHS, agreed with the analysis based on the documentation and everything. But when it got further up the chain, we were approaching like third step. It was not supported by the AG's office or OFM because they felt that it wasn't. If it's not in the PDF, it doesn't exist. It's not an essential function. So they contacted the appointing authority, and they were able to work with the individual, bring him back to work. They ended up creating a new position for him, and
which we don't do.
But it was a negotiation to bring him back because there was concern as to whether or not DSHS would win that case. There was some statements as far as, so you're telling me that there's no one else in DSHS that can move these cars? Well, we don't look at it that way. We look at what is this person's job, and can you perform your job? So, because by the time they ended up resolving that situation, the guy's position had already been filled with another incumbent. So they created a new position, brought him back to DSHS. So
it wasn't this AAG, by the way.
No, it wasn't. So again, keeping in mind that when you're looking at essential functions, I tell the supervisors, make sure your PDFs, because this is what tells what your job is. This is what is going to, if the employee challenges it, this is what the courts are going to be looking at. What is your job, employer? What is required out of the position? And so we push this really hard in DSHS, make sure it's up to date, make sure it's accurate, because if it's not on here, it's not essential.
I would just put in a caveat, even though I know we're kind of running low on time, but there was a case down in California, San Diego, I think, that involved law enforcement officers. And in their PDF, it said they had to be able to run, jump, pull out their gun, do whatever, right? It said that in their PDF. It was very clear. But in terms of a practice, there were people that worked desk jobs, and they never had to run, jump, pull out their guns. And the court actually said, you can have it in your PDF, and that's really good evidence that that's an essential function if it's in the PDF. But if in practice you don't make them do it, yeah, it's not so much an essential function anymore. So, I mean, that's sort of the flip side of the case that Connie was talking about. But keep that in mind. I mean, just because you put it in the PDF, if you don't make them do that essential function, then you kind of lose your argument about why it is an essential function.
Perfect. And the other things to consider is, again, position is highly specialized. The amount of time spent performing the function. Again, if you look at the EEOC guidance, the EEOC, which is the Equal Employment Opportunity Commission, they state that, for example, they use the example of an airline pilot. An airline pilot spends 90% of their day flying planes. 10% is taking off and landing. Does anyone think that taking off and landing is not an essential function for a pilot? They also look at a firefighter. A firefighter may never be required to carry an unconscious person out of a burning building. But what is the consequences if they were not able to perform that? So again,
the unconscious person, you would probably think that was essential.
Totally. All right. You can do this one.
Okay, obligation to provide reasonable accommodation. You have to, the employee has to have put the employer on notice, and we talked about how it might be a little different under the ADA versus the Washington law. But you have to know that there's an impairment, and at some point, if necessary, you need to have the medical documentation that establishes a reasonable likelihood that engaging in a job function without an accommodation would, oh, wait a minute, is this like the other part of the definition?
Yeah.
So this is a part of the definition that
the legislator changed after they went to the ADA. They added this piece.
Right. So if you think that what they're doing would aggravate their situation to the extent that it would create an impairment, then that would create a substantially limited effect on their job, then it is a disability.
So for example, they may not be substantially limited in their ability to perform their job now, but if the doctor says if they continue doing it this way, they're going to be substantially limited in the future. Our obligation is triggered now.
We
can't
still
wait.
haven't had our first case against Fred Meyer or whoever, because Fred Meyer gets a lot of these kind of cases, or Boeing. But I always think of, like, if you're working like maybe in a nursing home or at one of the state hospitals and you say you need a Hoyer lift to lift this patient, and they say, no, we're not going to give you a Hoyer lift to lift this patient, and then you end up with a back problem because of it. I think that's where this definition of you don't have it now, but if you're doing things that would aggravate you, then you might have one in the future. So that's a case that doesn't really happen very often. But the second bullet is kind of important about the definition of a disability in Washington, or how it's applied. You must have a substantially limited effect upon the individual's ability to perform their job. And so this is really important, because in Washington, there is a correlation between having the disability and doing the job. Unlike under the ADA, where we talk about a major life activity that may or may not be job related, actually, right?
Like reproduction.
Right,
They may need time off
reproduction.
for treatment. It's not an essential
Right.
function that they reproduce.
Right. My thought is that unless you're a surrogate, it's not probably, reproductive health is not necessarily an essential function of a person's job. I don't know. Let's see. Well, you can read the rest of the line. I don't know the sign.
Oh, the next piece is the individual's ability to apply and be considered for jobs, or their ability to access the benefits and privileges, terms and conditions of employment.
That's the kind of thing we're talking about, holiday parties and other kind of opportunities, the office golf tournament, things like that. So it's all aspects of the job, but also keep in mind there are other things too that might happen at work that are opportunities that everyone should have an opportunity to participate in.
And it covers all aspects of employment and current employees, even non-perm. You have an obligation to accommodate non-perm employees or probationary employees.
Mm-hmm.
All aspects you have obligations to accommodate.
If you have that kind of situation come up, you should call your AAG, and then I'll call Connie, and then we'll sort it out, because those are difficult situations when you have a non-perm, and they're often probably also not performing the job in the way that the manager would have hoped, but there's some other issue happening as well. You can always still probationary separate someone, but you have to have a non-discriminatory reason for having done it, right? That you can articulate.
And then the only other thing with that is the obligation is ongoing. So if you had a meeting with an employee last year, and you, during that interactive process, you identified, hey, here's an effective accommodation. This is going to remove the barrier for you. You put it in place, the employee is performing their job, and everything is going great. Now you get like 2 years down the road, and the employee is having issues again. And it could be because the medical condition has changed. So in some cases, maybe it's gotten worse. Or the job has changed. 36 years ago, when I started working for DSHS, we used IBM Selectric typewriters. Well, the way you do business changes every day. So we no longer use IBM Selectric typewriters. So again, if the job changes where the accommodation is no longer effective, even if it's a permanent accommodation that you put in place, if the job changes or the condition changes, you have an obligation to come back to the table with the individual and explain to them, here's how the job changed. The accommodation we provided you is no longer effective in the way we do business now. How can we accommodate you to perform the new job or the way the business has changed? So you come back and you reassess. The same way, if their condition has changed, it's no longer effective, you come back, you reassess with the employee.
The one thing that's not okay is if the supervisor changes and they come in and they say, well, what do you mean you don't have to show up until 10 o'clock in the morning? That's not okay. You need to start being here at 8 o'clock like everybody else. Then that can start an engagement about a conversation. There is actually a case with Fred Meyer where the employee worked in the wine department, and she was really great at her job and got awards, and she was wonderful. But in the winter, she needed to get off work like at 4 o'clock because she couldn't see very well to drive at night, right? It was a disability, and that's how it was accommodated. A new supervisor came in and said, well, you're going to work till 5 like everyone else all year long. And, guess what happened to Fred Meyer? they lost. So, Robin.
In the leading others supervisory training, there's an HR panel on the third day. And on that panel, there's a question about a supervisor coming in, brand new supervisor, has these direct reports, opens up a file and sees medical information in the file. And so, yeah, yes, that face, that alarm face, that shouldn't be there. But one of the questions I got on one of the panels was, well, what is it supposed to look like if a new supervisor walks in? How do they find out about standing reasonable accommodations? Because there's not information in the file. So does HR contact this new supervisor? Connie, like what does that look like at DSHS?
So normally they contact me or one of the specialists because earlier this year we went paperless. We don't have any paper files any longer. So everything is digital. And once we close our cases out, they're modused into a system, and just me and my specialist are the only ones who have access to those records. So they will contact one of us and say, hey, I got this new employee, or I'm the new supervisor for this employee, and the employee says that they have an accommodation in place. Can you confirm? And we can bring up the records and we can confirm what the accommodation is. We don't explain what the disability is or anything. We just confirm whether or not there is an existing accommodation in place. A lot of times we have the records, so we're able to tell the employee, but in some cases we don't. And the employee argues, this is something my previous supervisor gave me. It was an informal accommodation. When I hear informal accommodation, it basically means you didn't follow process. And the law doesn't make a distinction between formal or informal. But what I do tell supervisors is that if we have no record of it and the employee says that they have a medical need for it, let's open an RA case and work with them now. And so we do that.
What if the employee doesn't say anything? Like you get that, if they don't say anything, like in the Fred Meyer case, if that woman didn't say, my schedule is an accommodation, and so the supervisor just thinks, well, I don't know why she's got a weird schedule, I'm getting rid of that. Like, what if the employee doesn't tell the supervisor that what they have is for a medical accommodation?
Well, they're not responsible for what they don't know.
Right. I was going to say, I mean, then I don't know if we get sued, then I guess the defense is.
Well, the employee should have said something. You know, I mean, they have a little bit of responsibility.
Interactive does mean, yes, both sides.
We have this much responsibility. They have this much responsibility, but.
Okay, go quick.
Okay.
You talk faster than me.
All right. So reasonable accommodation, eyeglasses. We're not required to provide an employee eyeglasses, hearing aids, wheelchairs, personal assistance as a form of accommodation. However, if the eyeglasses are needed, like specialized eyeglasses for a specific job that the employee needs, then we would provide the specific special eyeglasses for them in the job. Hearing aids, we're not obligated to provide. I do know DSHS has done that a couple of times, but again, we're not obligated to. The wheelchairs, we have provided wheelchairs for employees, but from my knowledge, it's been for emergency evacuation and it's for use at work only. And personal assistance, we're not obligated to pay personal assistance except if the employee is in travel status. If the employee is in travel status and they have a personal assistant who assists them with toiletering, eating, bathing, dressing, those types of things. If the employee is in travel status, we have to pay for it. Travel. We pay the per diem and everything for them. Yeah.
That makes sense.
Yeah. But sometimes the accommodation is to allow the personal assistant to have access to the work environment. We have some employees who are either they're quadriplegic or they have some developmental disability or something, and if they have somebody who assists them, we give them access, we allow them to have access to the building or the facility. And there's different forms of accommodations. We're going to go through these pretty quickly. Job restructuring. Job restructuring basically allocates when and how a job function is performed. Now, these are just examples of accommodation. An example of a job allocation would be like if an employee has they say I have ADD or ADHD, my disability causes me to make errors on reports that I'm working on because of the constant interruptions from the phone. When my phone rings, I have to stop, I have to answer it, deal with that, then come back and work on my report. I forget where I left off, or that's where the errors are being made. So it could be potentially a form of accommodation to have the employee silence their phone so that they can focus on the working on the report. And when the report is done, come back and listen to messages and return phone calls. So again, it's a case-by-case analysis. So you have to look at, can those types of things be done?
Move on to leave.
Leave.
Leave is a big one.
Leave is huge. Huge. It seems like every year our legislators come up with new and great ideas for leave. So, so leave is a type of reasonable accommodation. I will say this in DSHS first. The first thing we look at is FEMLA. FEMLA is an entitlement. We always look at if it's a qualifying criteria for the job. When we're looking at disability, it would be a qualifying criteria. So we look at FEMLA first, and we work with the HR folks to determine, do they qualify for FEMLA? If they do, we designate. If the employee does not qualify for FEMLA, we now look at it under reasonable accommodation. Reasonable accommodation looks at leave much differently than FEMLA, where FEMLA says this is how much leave you get regardless of whether your condition is permanent or not, and once you've exhausted it for that 1 year period, it's done. But under reasonable accommodation, we're looking at is leave effective? So if you're looking at, and normally my staff are looking at frequency and duration. So if you've got an employee who's missing 1 to 2 days per month due to their medical condition, can they still perform the essential functions of their job? Probably, right? They get over that much leave every month anyways. But yeah, they could probably still perform the essential functions of their job missing 1 to 2 days per month. Now you change the scenario. You have an employee who has a medical condition which requires them to miss 1 to 2 days per week. Can they still perform the full-time essential functions of the job missing 1 to 2 days per week?
Forever.
Forever. Probably not. So it may not be an effective form of accommodation, and it would be denied under reasonable accommodation, and the case would be moved to reassignment to look for a part-time position.
Okay.
It says, I work at DSHS. Does RA follow an employee if they transfer to a different office, or do they have to request RA again and go through the RA process again?
So, good question. A reasonable accommodation does not necessarily follow the employee to a new job. And the reason why is it's a case-by-case analysis. You're looking at the essential functions of the job. How does the employee's medical condition affect their ability to perform the essential functions? If they move to a new job, the essential functions have now changed, right? Well probably,
maybe, unless they move into the exact same kind of job.
So if the essential functions has changed, then that would become a new analysis. If the essential functions of the job have not changed, then the employee's accommodation would follow them into the new position, as long as it's effective.
But change the facts, change the answer. That's what I always say.
Yeah, but I will say this, DSHS is really great about allowing employees to take like equipment, furniture, stuff like that, that they've been accommodated with in one position. If they need it in the new position within DSHS, they're pretty good about allowing the employee to take it with them. So
we're talking about indefinite leave.
Yeah, indefinite leave. Lengthy or indefinite leave is not a form of accommodation, and there's no obligation to provide that accommodation. However, my advice is that you be interacting with the employee during that process, and also going back and seeking medical from the doctor. Our practice is that we always look at FEMLA first, so the employee under the FEMLA process is required to provide medical for that. If the FEMLA is exhausted and they need leave beyond the FEMLA, as soon as they exhaust their FEMLA, the case is referred to one of the specialists. The first thing the specialist is going to do is going to go back to the doctor. We go back and we give the doctor the history. This is how long this has been going on. This is how often the employee is out. So in some cases, the employee has been requesting FEMLA for the last 7-8 years, and maybe they're gradually using more and more leave. And so we provide all that information to the doctor, and then we ask the doctor our questions. And based on the medical information we get back from the doctor, if it's something we can accommodate, again, 1 to 2 days per month, yeah, that's something we could accommodate. But if the doctor says the employee only needs 3 more months of leave, we're going to grant the additional leave.
Unless it's the third time that we've done
Unless,
that.
exactly.
Or the fourth or the
So
fifth.
if the doctor says, which was the case that
Mhm.
went to arbitration, where the employee exhausted her FMLA, the doctor came back and said, we sought medical, the doctor came back, said she just needs 60 more days. So we gave her the 60 more days. When the 60 days was up, the doctor came back, said it needs 60 more days. So we authorized the additional 60 more days, and they met with her and they told her, okay, so we're hoping you can come back on this date. That's the goal, that's the hope. But if you're not able to come back on this date, we're going to be
she'd
looking
been out
at.
for a year at that point.
She had been out a year by the time we separated her. So, and she had legitimate medical issues.
Yes,
there was nothing questioning her.
Absolutely.
She had some very serious stuff going on. But the issue is that it became indefinite leave because although the doctor was providing predictability, the employee was not able to return to work on the dates that the doctor provided us. And so that is always going to help your case when you're working with the doctor, working with the employee to show that's indefinite and seeking that medical. So as soon as the doctor says, this is the time frame, that time frame runs out, you're following up with the doctor and saying, is she able to return to work on this date? Does she have any restrictions we need to be aware of to accommodate? But if the doctor keeps saying, we usually look about the 3rd or 4th time, depending on how long a period they've been out, we're now looking at, because I tell my specialist, meet with the employee early on so that they understand we're not obligated to give you lengthy or indefinite leave. Because if you wait until the first time you're meeting with them and saying, okay, this is the 4th time, we're not going to do it anymore. What you're probably going to get back is a scared employee running back to their doctor, going to get a full release, no restriction, even though they may not be able to return to work or may still continue to have limitations. So
we do have a question on the phone. Can you define lengthy?
I think I just did. Where the lengthy, the law doesn't specifically say you get 9 months and now you're in lengthy leave. I mean, there's no specific definition. So I think you have to look at everything cumulatively. So what was provided under FMLA? What is the employee provided beyond the FMLA? What is the doctor saying? So it's a case-by-case analysis to say, we don't put a time frame on it.
It's a catch-22. The courts have said indefinite leave is definitely not an accommodation, but of course they don't tell us what indefinite means. So it's a judgment call every time you do it too, right? It's a risk analysis when you say this is it, and you just hope that the jury agrees with you. There's a question in the back, Robin, but we're like about a minute and a half at a time. We've talked about reassignment a little bit. Let's see, we could talk a little bit about defenses for not providing accommodation. Those are pretty much undue hardship. But I really think it might be best if we saved discussion on those things and went back to some of the last slides on discipline and service animals. Go ahead.
Does this meeting go till 3:30 or 4?
3:30 it said.
No.
In the announcement I saw, it said 3:30.
I think some people were planning to stay a little longer, but if there's confusion. You want to ask your question?
Go ahead and ask your question.
I was just curious if so FMLA is starting to be paid in January, I heard.
It's starting what?
FMLA is going to be paid in January.
No. Those are two different laws. Laws.
Okay.
FMLA is that you're talking about the Family Medical Leave Act. That's a federal law. That will stay the same.
Okay.
In January, the paid family medical leave, that's a state law. That's going to replace the old Family Leave Act, which is the old state law. It's going to replace that one.
True story. I know people that have retired because they don't want to deal with all the new leave laws that are coming up. Just saying. Okay. Do you want to talk about discipline in RA?
Discipline in RA. So I know this doesn't happen very often in your areas, but sometimes an employee is in the middle of an investigation or is having issues outside of disability. and they request a reasonable accommodation. So what we always do is we keep those two things separate. Now, if the employee is tying their disability to something that they're being disciplined for, again, it's what did you know and when did you know it? I mean, again, the employer is not obligated. So if they're in an NOI, for DSHS, that's notice of intent to discipline. So if they're at the NOI meeting and they're proceeding with just cause and looking at taking an action, a disciplinary action on the employee based on something that during that meeting, the employee brings in a medical statement saying, hey, I've been treating this patient for this condition for years, and they have these limitations for which you're disciplining them for. Again, if management didn't have notice, they are not required to stop their action. I get a lot of calls on this around DSHS, so if the employer had knowledge and did nothing about it, I'm probably going to advise that they stop their action, accommodate the employee first to see whether or not it fixes the situation. But again,
which doesn't mean just throw out just cause and forget
Exactly.
about it forever. It just means pause.
It just means pause. But if the employer had no notice, what I tell management, so if you're at a place where you're looking at taking a suspension or a cut and pay, proceed with your action, but also open a reasonable accommodation case and go down that process. Stress is not a disability, but it may exacerbate a disability. And that's when it triggers your obligation to accommodate, is if stress is exacerbated, like MS.
Yes.
So if the employee says the stressors of something in the workplace are triggering my medical condition, now we have obligations to consider it, to go through our process to accommodate. But just stressed out, I don't know anyone who doesn't get stressed, especially in the HR world.
Mm-hmm.
You're not obligated to accommodate stress. Clash with supervisors, you don't get a new supervisor in the RA process. You don't get new coworkers in the reasonable accommodation process. We live in an equal employment opportunity world. You have an equal employment opportunity to work for a not so good supervisor. So, but again, there's a separate process, and we tell employees that's a separate process to address that. I don't know. I know in DSHS we're seeing more and more situations where employees are requesting accommodations to telework from home because their supervisor is stressing them out. It's kind of like not an effective accommodation because you're still reporting to your supervisor, and just because you're not in the environment doesn't mean that you're not still interacting.
Having said that, sometimes we accommodate people by saying that they're going to get their directions in writing rather than person. But
you can accommodate supervisory methods, but you can't impede a supervisor's ability to do their job.
Along with indefinite leave, this changing the supervisor is just one other small little, like, this is definitely a rule in reasonable accommodation, because generally cases always say it's on a case-by-case basis. But service animals. So as you know, service animals you must allow those into the workplace, right? And so if you have a trained service animal who's performing a particular function, we most often see guide dogs, sometimes miniature horses, apparently, because that's what the statute talks about. Don't ask me why. So that's a given. But we've seen more and more cases where people want to bring their comfort or emotional support animal to work. And we treat that as a reasonable accommodation situation where we say, is this the accommodation? We go through the whole process. Is this the accommodation that would be most effective? We run into problems all the time with, coworkers not wanting the fleas or the whatever. Obviously, any kind of support animal or service animal has to be well behaved without fleas, those sorts of things. They have to be okay in the workplace. But nonetheless, there are conflicts that arise sometimes in these situations. And you just have to try to work through them as best you can.
So for service animals, the dog has to be specifically trained to perform work or a task due to the employee's disability. So again, if the employee says, well, I pick up my dog because I get stressed and I pet my dog and I feel better, that dog is not trained to be anything but cute. And so it's not really trained to do anything.
Unless somehow they're trained to know if your blood sugar is getting low.
But they have to be able to notify you somehow. Right. Trained to notify you of that. So
there's not a whole lot of rules around being trained or not trained, or who has to train you and who has to. Exactly. There's no certification. There's no, right? Yeah. So it's a little murky.
What we tell because we have, I mean, again, I'm a dog lover, so I love dogs and stuff. I'd love to have one with me myself. But again, they have to be specifically trained. And what DSHS's process is we seek medical information from the doctor. We never ask the doctor anything about the dog, because the doctor calling the dog a service animal doesn't make it a service animal. Again, we ask about the disability. We ask questions about the disability. Then when we get the medical information, we sit down and we have an interactive meeting with the employee, and we ask the employee, based on the medical that your doctor provided, what work or task is your dog trained to perform for you? And if the dog is specifically trained to perform work or task due to their disability, they are a service animal. But wearing a vest saying service animal doesn't make them a service animal, or having a certificate saying Fido is a service animal doesn't make it a service animal. They can get that for a few dollars online. And so again, it has to meet that definition, and that's part of the interactive process. So you should be engaging with your employees at that point.
Okay, final slide about alcohol and,
Addiction.
Alcohol and addiction.
So alcoholism, drug addiction are disabilities. However, we don't accommodate use. If the employee is actively using, if they're showing up under the influence, enforce your performance process. If the employee is missing time from work due to active use, that is not covered or protected either. The only thing that we would protect or that we would accommodate the employee is if the employee is seeking treatment. If the employee is seeking outpatient treatment or treatment that would conflict with work, you go through your process, you seek the medical information. We do meet with the employee and we inform employees, because we've had several situations over the years where employees say, I need 21 days off for inpatient treatment. We've authorized the time off, and then we find out after 2 days they left treatment and they did not return to work. So we tell employees that we're going to give you this time off so you can get the treatment that you need. However, if you do not return to work, or if you choose to leave treatment, you better return to work immediately. If you don't return to work, that authorized leave now becomes unauthorized. So it's only authorized while you're participating in treatment. So we do get the verification from the doctor. When me and my staff are involved, we get the verification from the doctor, and we also require the employee to provide verification that they completed the treatment as well. And that authorizes the time off and protects that time for the employee.
Cool. Good job.
Any questions?
Any last questions? Lots of questions. Well, you can always call your AAG.
I think that Robin has some.
I was just going to share that the slides that were used for today's training will be posted on the OFM website with Connie's permission, of course. Is
Yeah,
that okay?
it's fine.
So we'll post them on the ofm.wa.gov website in the state HR section under the meetings. So if you want to go and review the slides we didn't get to cover today, and also if you want contact information, those will be posted online.
Thank you, guys.
Thanks. Thanks for moderating, Elizabeth.
Of course. Yes, thank you.
The person on the phone said, oh, there was a person who said, thank you for your insight. But there was one person who asked if it was required for the agency to follow up on accommodations to verify its work.
To verify its what?
Oh, you mean follow